Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Professor Kavita Solanki at University School of Law and Legal Studies, Guru Gobind Singh, Indraprastha University, Delhi, Dwarka. So today we'll talk about Labor and Industrial Law Part 2, into which lecture number 7, Occupational Safety, Health and Working Conditions Code 2020. This code was the second code which was enacted, which was passed by the Lok Sabha and the Rajya Sabha after the Code on Wages in 2019. Into this code, we have amalgamated 13 legislations. Because the reason being to pass this code is because into all these 13 acts, we are having the multiple things, we are repeating multiple things into respective legislations. So into this code, just this code has been drafted in such a way just to simplify all these laws and where we can use the digital platforms. So this is, it compensates with the technical use. Into this code, many definitions has been incorporated and the changes has been made into the so many definitions. The earlier 13 legislation where we had multiple sections, but now they had been reduced into the 143 sections and we are with the 3 schedules. That is the health, safety and the working conditions of the employees, and we are casting the duties upon the employers. Sometimes when we talk about the manufacturer's responsibility, we are talking about about the designers or the architect or the engineer's responsibility, because a new thing has been added, because nowadays even like a single window system we are having. Earlier we used to say that the woman cannot work into the industry after the sunset and the before sunrise. Now we have changed this, and now the female, they can work into any of the industrial establishment after the sunset and the before sunrise, and where we are like this kind of the provisions has been made where the workers they would be feeling secure environment, and we are giving the protection to the interstate migrant workers, building and the construction workers. We are talking of the contract workers, sign workers, audio visual workers, journalists. We are talking about we have included the mine workers, we are talking about the factory workers. So the broad umbrella has been provided under this code, and this code has been simplified because now we are saying that like utmost responsibility has been imposed upon the employers and the contractor. Now the contractor comes under the definition of the employer, so more responsibilities has been assigned it to the contractor. This is not the job of the contractor is to bring the provide the labor force, but to completion of the task is the responsibility of the employer. If someone is entering into kind of the agreement, say when we talk about audio visual workers, the agreement has to be drafted in a prescribed format, and if someone is ready to go for the overtime of the work, then in that case the consent has to be taken by that person. So because this thing has been taken care of how these persons can be protected, so not only by providing the welfare benefit has been given, and when we talk about the new thing has been set up under this code is that is worker reskilling fund has been created for the unorganized sector workers. So otherwise normally the problems comes from which head we can take this kind of the funds. So this fund has been created for the help of the unorganized workers. So when we talk about this code, we are having the 14 chapters and the 3 schedules which has been given under this Occupational Safety, Health and the Working Conditions Code. And this code was introduced into the Lok Sabha on 19th of September 2020 and passed by the Lok Sabha on 22nd September 2020, passed by the Rajya Sabha on 23rd September in the same year 2020, and the President gave the assent on 28th of September 2020. As I discussed, this code is having 14 chapters and 143 sections, and 3 schedules has been given. So that is structure of this code is the first is section 1 and 2 because the applicability of this code when the title, commencement and the application, and here this section 2 deals with the definition portion as usual, and here we are having the procedure for the registration under this of certain establishment under this code. In chapter 3 we are having the duties of the employers and the employees, and the duties has been cast upon the owners, and the duties of the managers and the agent in relation to the mines, duties of the designers, manufacturers, importers and the suppliers, duties of the architect and project engineers and the designer in section 9. So the duties has been cast upon these persons. After that we are having the occupational safety and the health provisions has been given. And we are having the health, safety and the working conditions. Welfare provisions has been set up in section 24. Number of the hours and the annual leave with the wages for the workers, and maintenance of the register and the records and the returns. This is the duty of the employer. And we are having the inspector cum facilitator and other authorities which has been set up. So when we are using the term inspector is already inspector into the earlier legislation, but now just to that's why this nomenclature has been changed, because now this inspector is inspector cum facilitator. So and the different methods has been set up for the inspection under this code. And we are having the provision for the employment of the women. So the women, they can do the work into any of the establishments and into all the sectors after the sunset and before sunrise. Earlier this kind of the restriction was imposed. If the employer sometimes they feel so there is a danger is there, or this kind of the work is hazardous, then in that case this is the duty of the employer. They must have to make the arrangement for the protection of the this female worker. That is so that's why we are having the special provisions for the employment of the women, and we are having the special provisions for the contract labor, interstate migrant workers. Offenses and the penalties has been given in chapter 12, and we are having the social security fund which has been created in section 115 and for the purpose of the unorganized workers. And last chapter is chapter 14, deals with the miscellaneous provisions. So the purpose of this code, the objective is to provide the safe and the healthy working conditions, and in all the workplaces, either factory, mines, docks, construction site and more. And this code ensures the risk prevention. So here we are having the concept is prevention is better than cure. So risk prevention here, and workplace inspection we are having for this. The safety officers are there and the health standards has been set up. And this code would be applicable. Uniform standards has been set up of the safety and the welfare across all the sectors. So it includes contract workers. So they are also having the similar uniform standards of the safety and the welfare. Like contract workers, interstate migrant workers, workers in an unorganized sector, audio visual workers, and it applies to the establishment with 10 or more workers, but we are having the exception for the hazardous process. And it introduces a single registration, and because we are having the single window system, so single registration and the licensing and these kind of the formalities is the responsibility of the employer. So it has been cast upon the employer. So this thing can be return filing for ease of compliance. Like this is the responsibility of the employer. And this code basically promotes the use of technology. So either electronic records or the online registration. So this code promotes the technology, and it allows the women to work into all types of the establishments and in all the shifts, including the night shifts. But for this their consent is required, and this is the duty of the employer. They must have to provide the safety safeguards into that places. And for this, like for the unorganized sectors, the special fund has been created because these 3 schedules are given under this code. So first schedule deals with the list of the injuries involving the hazardous process. So it has been defined in section 2 clause ZA, list of the industries. So the list has been cited of these industries which involve the hazardous processes. For this till date we are having the 40 list of the industries has been cited. Into the second schedule is, here the central government is having the power to declare the occupational safety and the health standards which has to be followed. So either safety norms, or like this is whether someone is doing the work into the machine, like all the safety standards has been, these kind of the norms has been set up by the central government, which they have to follow only, and they are relating to the hazards. So norm has been, cited into this schedule. So till date these standards, so 72 matter has been cited where they require these, safety standards, and 73rd matter. So here the central government is the competent government. They can, add any other matter with the field. So it has to be added with this second schedule. So total we are having the 73 point has been given into second schedule. The third schedule, so it talks about, it deals with, with the list of the notifiable disease. So whom we would be saying the notifiable disease, like we can say the occupation disease. So for this the list has been indicated, and there are 29 notifiable diseases are cited under the third schedule. So this is like for this purpose we have amalgamated the 13 legislation. When we talk about these 13 legislations, we are having that is Factory Act 1948, Plantation Labor Act 1951, the Mines Act 1952, the Working Journalist and Other Newspaper Employees Condition of Service and the Miscellaneous Provisions Act 1955, the Working Journalist Fixation of Rates of Wages Act 1958, the Motor Transport Workers 1961, the BD and the Cigar Workers Condition of Employment Act 1966, the Contract Labor Regulation and Abolition Act 1970, and the Sale Promotion Employees Condition of Service Act 1976, the Interstate Migrant Workmen Regulation of Employment and Condition of Service Act 1979, the Sign Workers and Cinema Theatre Workers Act 1981, the Dock Workers Safety, Health and Welfare Act 1996, and the last one is the Building and the Other Construction Workers Regulation of Employment and Condition of Service Act 1996. So for this purpose of this code, these 13 legislations has been amalgamated, and the total sections of this legislation from these 13 legislations are 622 in number. So into 13 legislations we are having a total section 622. Now we have reduced this section up to section 143 under the code on occupational health and safety conditions code. This code basically it provides a broader legislative framework to secure just and the human conditions of the work with flexibility. This code provides enabling provisions for making the rules and the regulations in tune with the emerging technology, and through this code, like the intention is to avoid repetition of the provisions which has been given under the 13 legislations. So important definitions has been given, because into all the codes we are having the similar definitions. Throughout the 4 codes we are having the similar definition either. So now the contractor has been given under the definition of the employer. Factories, so into the factories, so now under this code this threshold has been changed. Earlier we were talking about if any kind of the work which is going on with the aid of the power, the number of the worker were 10, but now it has been just double. So here 20 workers are required, and in case of the manual work without the aid of the power, earlier it was the 20, but now it is 40. So now this threshold has been changed. This Factory Act. So important definitions has been given. Hazardous process, whom we would be saying the hazardous process. So because hazardous process, it means basically it causes the material impairment to the health of the person, those who are engaged into that particular work or they are connected with it. So the result is into the pollution of the general environment. This hazardous process, whom we would be saying the hazardous process. For this purpose we are having the schedule 1 where that is the list of the industries has been cited, those who are coming under the definition of the hazardous process. Yes, applicability of this code is, this is applicable to a place where any industry or like trade, business, manufacturing or the occupation is carried on, and in which 10 or more persons are employed. So normally, because under this code is applicability, so the threshold of the worker has been, the number has been changed. So this code would be applicable any of the industry, trade or business or the manufacturing or any occupation is carried on. So the minimum number of the worker has to be 10 or more they are employed. The motor transport related establishment, or when we say the newspaper or media establishment, audio video making or production establishments, or building or the other construction like workers, or any kind of the modification which is related to this, or any plantation worker, so it would be applicable where the number of the workers has to be employed 10 or more, then this code would be applicable. So minimum threshold has been fixed, that is for these sectors, for these employments, the number of the worker has to be minimum 10, and they are doing the work into the last proceeding last years, so they have to be there employed into the previous year. The establishment in which either hazardous or the life threatening activities carried on, then in that case no threshold has been given. Mines or the ports, or areas which are near the ports, or we can say the vicinity of the port where the dock work is performed, then again here no threshold is given, no number of the worker is given. So for the hazardous work or the mine and the ports, so no threshold has been, no limit has been fixed. The factory, as I discussed, the minimum is like in case of the manual work is going on, that is the 40, but if the work is going on with the help of the power, then that is the 40. So 20 and the 40 we are having. The definitions, contract labor. So into the contract labor, this code would be applicable, and we are having the 50 or more contract labor. So interstate migrant workers, if they are doing the work into any of the establishment, so they have to employ 10 or more interstate migrant workers. So, and after that definition, now we are having the wide definitions. It means like wide means we have modified the definition, we have added the definition under the code, because into the code is a definition of the employee is very, very important. And as I discussed earlier, employer, factory, hazardous process, and many more definitions are has been given. So few important definition I'm taking it here. So because the control industry is again an important definition. The core activity of an establishment, it has been defined in section 2p, again an important definition. Building and the other construction worker, so now technological requirements, so it includes the internet towers, so those who are doing the work into the internet towers, so like it has been added. And the contractor here under this code is with the more responsibility, and definition of the family is added here under this code. And here the definition of the family, here grandparents has been included under the definition of the family. Industry, so like definition of the industry is given, motor transport workers and the other, they have been added under this code. I mean where the definition has been modified. So or like the modification we have added like other components. The definition of the sign worker, it has been modified, and we have added into the sign worker. So we have added into the definition all audio visual workers. So all audio visual workers, we are talking about the actors to the skilled and the unskilled workers, those who are involving into the production work. So now the more scope has been given, so the more coverage has been given under the definition of the sign workers. Working journalist, this definition, it has been modified, and we have included journalist working in the electronic media. So they have been added. And when the definition of the family, as I've discussed earlier, so grandparents has been added into the definition of the family, because they are the dependent. And into the interstate migrant workers, here either the person they have been directly employed, or they are employed by the employer or through the contractor. So this definition has been modified and they have added more components. So the broad umbrella has been provided for the protection of these workers. So after that, under this code, so section 3 is talking about, that is a registration of certain establishment under this code. So registration of these certain establishments, so these kind of the establishments which came after the commencement of this code is, so this is the duty of the employer is what they have to do within 60 days from the date of the applicability of this code, because this code has not been we are waiting for the already this code has been passed, but we are waiting for the date for the notification. So this is the duty of the employer. They have to within 60 days from the date of such a applicability, they would be making an application and by the electronic means to the registering officer, which has been appointed by the appropriate government for the registration of such a establishment. So they would be giving the application just to register themselves to the registering officer. So this is the duty of the employer. And because a 60 days period has been given, but by chance if someone is having the reasonable reason for making the delay, then in that case, because the late fee can be charged by the appropriate government, and they feel so there is a genuine reason for making the delay. And under this code, we are adapting the new changes into the healthy, safety and the welfare condition of the workers. So for this, there is a provision for the appointment letter has been given to the workers, and it is a mandatory for the employer to give the appointment letter. And this is a duty of the employer is to go for the annual checkup of the workers. This is the duty of the employer. They must have to go provide this free annual checkup, and so no charge can be imposed upon the workers if they are going for this. So they must have to take care of these things. And interstate migrant workers, so they can register themselves online, because we are having the Aadhaar is there, and for this purpose the helpline number has been provided. The duty of the employer is the more the special provisions has been created under this code. So because the fair expenses has to be bear by the employer, and for the better functioning we are having the board has been constituted. So under this code is that is the minimum wages has been fixed for the for the migrant worker is 18,000 per month has been fixed by the government. So this is these kind of the few provisions has been added. And for the administration of the code, the safety committee has been constituted by the appropriate government, and it is very much required for the contractor. They must have to take the license, and so the license can be given. But if the employer wants to take the single license for the all India license, if they want to get for the 5 years for the contractor workers, so it can be if they are comply with all the requirements which has been cited. So this kind of the license can be issued to the contractor and for 5 years. And we are having the provisions for the holidays and these kind of things has been added. And the intention is for the enhancing the health and the safety benefit for all these employees. Duties of the employees. So here the duties of the employer has been discussed here, because it is the duty of the employer is they would be issued the appointment letter. Appointment letter would be given it to the person. And see, by chance if something has happened, if any kind of the accident has happened into the industry establishment, then this is the duty of the person is they must have to inform to the appropriate government. And it is the duty has been cast under this code of the employees. They should take care of their own health, and they are having the right to informed. So if this someone wants to know that what kind of the benefit has been given to us, so this is their right. See, employer cannot deny if the employee wants to know what kind of the facility has been provided to these workers, to these employees. So this is the duty of the employer. They must have to tell all each and every information which is important for the these workers or these employees. So if they want to know, this is the duty of the employer is, if someone is doing the work into any of the workplace, it has to be free from the hazards, and if any kind of the injury or the occupation disease is there, has been caused to the employee, then in that case they must have to take care and they must have to inform the appropriate government. And so we are having the system for the annual health examination that would be free of cost of all these employees. For this, they would be maintaining a register, and so they would be making all these informations, and they have to provide this working environment that is a safe for the health of the employees. Employer has to ensure that disposal of the hazardous and the toxic waste, including the disposal of the e-waste. So this is the responsibility of the employer. They must have to take care of the disposal of the all the toxic waste and the hazardous, and they can't ignore the e-waste. Sometime employer is taking the excuse, like if any accident has happened, like person is saying this was without my knowledge. So this kind of the excuse cannot be granted to the employer. Employer would be responsible in any case if any kind of the accident, injury or the death has been caused, and even without the knowledge of the person, like who is doing the work into the establishment, the person cannot ignore the responsibility. He would be accountable under this code. The duties of the employees. So here, this is the duty has been given. So again, duty of the employees, it has been given in section 13, and here they have to take care of their health and the safety of himself and the other persons as well. So like if any kind of the act of the omission is there, so they must have to comply with the safety and the health requirements which has been specified into the standards. They must have to cooperate with the employer and in meeting with the statutory obligations of the employer. See, sometime if the employer is giving the instruction, wear the helmet, take care of this kind of the safety devices, if the person doesn't ready to listen anything, then this is the duty of the employer. They must have to take care of all these things. And so if anything has happened, so in that case the report has to be given to the employer. And if the person is doing the work into the mine, this is duty of the agent or the manager. And we are having the safety officers has been appointed. They would be informing it to the appropriate government. They would be sending the report to the employer, and they would be informing to the appropriate government as well in the manner which has been prescribed. So they cannot misuse or neglect any kind of the appliances or this kind of the which has been provided for the safety of the workers. And they would be they must have to perform the duties which has been prescribed for by the government. So when we are talking about the rights of these workers, is they are having the right to obtain the informations, and if they are having the reasonable apprehensions, like imminent serious danger is there and the personal injury has been caused or the death is there, then they can inform to the employer and to the government, and so they can inform even to the inspector cum facilitator, and they can take the remedial actions. And if the employer is not convinced, sometime not ready to listen, then in that case they can inform the inspector cum facilitator. So the decision of the inspector cum facilitator would be final. For the administration of the OSH code, for this for the purpose of this, setting up of the National Occupational Safety and the Health Advisory Board at the national level, and on the other hand, when we talk about the State Occupational Safety and the Health Advisory Board has been set up at the state level in section 16 at the central level, and in section 18 at the state level. So these persons, they would be, because these persons, so for these because into the National Occupation Safety and the Health Advisory level, we are having these members, central government they can appoint, they can constitute National Occupational Safety and the Health Advisory Board, and they would be discharging their functions, and they can advise the central government and on the matter basically relating to the standards, rules and the regulations which has to be framed for the better implementation of this act, and they can issue the policy and the programs and the occupation safety and the matter which they feel so like time to time they can give the advices to the central government. The constitution of the members of the national board, there would be the secretary, and secretary from the Ministry of Labour and the Employment. The person would be the ex-chairman, the chairperson would be the ex-officio member, and Director General has to be there. Factory Advice Service and the Labour Institutes, Mumbai, we are having Director General Mine Safety, Dhanbad, they are the member ex officio, so we are having many ex officio members. So Director General Mine Safety, Dhanbad, Chief Controller of Explosive, from Nagpur, Chairperson, Central Pollution Control Board, New Delhi, Chief Labour Commissioner, Central, New Delhi, Principal Secretary dealing with the labour matters of the 4 states. So it can be done by the rotation as the central government may deem fit. And the Director General Employee State Insurance Corporation, New Delhi, and the Director General Health Services, New Delhi, 5 representatives from the employer side and the 5 representatives from the employee side, and the representation of the professional bodies which are associated with the standards, use, policies, and the 5 eminent persons has to be connected with the field of the occupational safety and health, and the representative from the reputed research institutions, and special invited from the government side, or it can be from the union territory. So they can be the these members, they are into this thing. So what they can do is they can declare, they can notify that the standards on the occupational safety, health of workers relating to the factory, mines, dock works, BD and the cigar workers, building and the other construction workers and the other establishments. So they can declare the standards, and so they would be setting the norms, and they would be giving the the relevant symptoms and the appropriate energy treatments and the proper conditions for the safe use, and and the monitoring purpose can be done, medical examination and the other tests can be made by the employer or their cost, so to these employees which are exposed to the hazards. So that's why these advisory bodies has been set up, and into this act, so we are having the state advisory bodies as well. So into section 19 we are having the research related activities on the occupational safety and the health. So it imposes basically duties on such institutes that can be notified by the central government, and they can go for the research and they can go for the experiments and they demonstrate leading to the occupational safety and the health, and later on they would be submitting their recommendations to the appropriate government. And section 21 the imposes the duty upon the central government and the state governments to ready with the statistics, and we are having safety in the occupational health surveys. So officers has been appointed for this purpose, so to conduct the surveys. So written notice has to be given to the employer for this purpose. So chief inspector cum facilitator for a factory or the mine, Director General of a factory advice service, they can go for these kind of the survey. Director General of Mines, Director General of Health Services or other authorized person whom the appropriate government is appointing, they can go for the surveys, and they can examine, test the plant, machinery, collection of the samples, and they can collect the relevant data. So they can go for these kind of things. So when they are going for these testings, so there is a duty of these workers, they must have to present themselves for the medical examination and provide all the relevant informations. So they would be giving all these information. So and this kind of the report would be submitted to the appropriate government by the inspector cum facilitator. Here in section 22 we are having the safety committees, and the safety officers has been appointed. So for the safety committee, equal representation has to be given by the employer side and the employee side, but these persons, employer and the employee, they would be appointed by the they would be chosen by the appropriate government. And the safety officers, So they would be checking, they would be seeing the compliance which has been adhered by the occupational safety. So this is the mandatory for the employer to appoint the safety officers in a factory, building and the other construction workers. For the building and the other construction workers, if they are having 500 or more workers, then they must have to appoint the safety officers. In case of the mines, if they are having the 100 or more workers, they must have to appoint the safety officers. Hazardous process, if they are having the 250 workers, they must have to appoint the safety officers. So this is the duty of these officers. Chapter 5, it talks about responsibility of the employer for maintaining health, safety and the working conditions. So this is the duty of the employer is to maintain in his establishment. So what they have to do, they have to take care of the few matters like into the establishment or the class of the establishment. They have to take care of the cleanliness and the hygiene, ventilation, temperature and the humidity. Environment has to be free from dust, noxious gases, fumes and the other impurities. Adequate standards of humidification they must have to follow. Artificially increasing the humidity into the air, they, like say for example, if they are doing the work where they are producing the hot environment, and so they must have to take care of this thing, how they can increase the humidity into the air, like ventilation and the cooling of the air into that workroom. Portable drinking water facility has to be provided. Adequate standards to prevent overcrowding. They must have to provide sufficient space for the employees and the other persons, so like they can do the work efficiently and they can avoid the overcrowding. Adequate lighting has to be there. Sufficient arrangement for the latrines and the urinal accommodation for male, female and the transgender employee separately, and maintaining hygiene therein. So here under this code we are talking about the transgender. So transgender people can be employed, and for this is the duty of the employer. They must have to take care of the special provisions if they have hired the transgender into the establishments. Effective arrangement for the treatment of the waste and the effluents, and the other arrangement can be made if the central government consider it is necessary. And we are having the welfare facilities into the establishment. This is the duty of the employer. They must have to take care of the welfare, means for their workers into their respective establishments. So for this purpose, this employer would be responsible to maintain all this kind of the facilities which has been prescribed by the central government, say adequate and the suitable facilities for washing to the male and the female employees, and bathing places and the locker rooms for the male, female and the transgender. So they are doing the work, so they must have to make the separate arrangement. And the workplace for keeping clothing not worn during the working hours, and the arrangement where they can keep their clothes, and the drying of the wet clothes. Sitting arrangement for all these employees, those who are doing the work into the standing position. Facilities of the canteen has to be provided if they are having the 100 workers, so into any of the establishments. And they can include the contract laborers into that. And in case of the mines, so medical examination of the employees is mandatory before they proceed for the work. So and they have to be given the specific intervals has to be provided, and adequate first aid boxes or the cupboards with the contents, they have to be readily accessible during all the working hours. And the other welfare means with the central government consider, and they can provide for the decent standard of the life of the workers. So if the central government feels so, the other arrangements can be made, that is number of hours. So into this daily and the weekly working hours, so no worker shall be recruited or allowed to work into any of the establishment more than 8 hours in a day. They can't give the work more than that. And when we spread over this, so see sometime what happened, if someone is doing the work into the shift, and if the person is entitled for a 1 day off, so 1 day off means 24 hours consecutive has to be provided to the worker. If we say this is a day off, so the spreading has to be in that way. into the mines, if the someone is doing the work into the mines, then the person who has been employed below the ground into the mine shall not be allowed to the work which has been specified by the central government. So they can't do this kind. If the someone is doing the work into the shifts, so again the time period has to be notified by the central government. So then in that case, and the entry of these persons has to be made into the registers. It has to be maintained for this purpose. So hours of work in case of the motor transport, so in that case the time into the work done during the running time of the transport. If the someone is running the transport at the time the person is driving, then in that case this time period has to be counted in case of the motor transport. And the time spent in the subsidiary work if the person is doing it, it has to be inclusive of the hour. And the period of the mere attendance at the terminal is less than the 15 minutes. So, and the weekly and the compensatory holiday has to be provided. So no worker shall be allowed to work into any of the establishment for more than 6 days in a week. And the extra wages has to be provided. If the someone is doing the work, overtime rate of the wages, then in that case, if the someone, this kind of the benefit has to be given. So just double wages has to be given to the workers in that case. So like person can enjoy this thing. But for this, under the code, the consent is required. If someone is ready to do the work, earlier we were not talking about the consent, but here the consent is mandatory from the worker side. And so even for the like overtime work, the appropriate government, they can prescribe the total numbers of the hours for the overtime work. And here see prohibition of the overlapping shift. No work shall be carried on in section 29, that is in any of the establishment by means of a shift so arranged that is more than one relay of the workers is engaged of the work at the same kind and at the same time. So this is the overlapping shift has been avoided. Night shifts, so as I discussed, that is a 24 consecutive hours has to be given. And there is a restriction has been imposed in section 13, that is relating to the double employment in a factory. The someone is doing the work into the factory and into the mines, because nowadays one of the concept is moonlighting. So but here either someone is doing the work into the mines or into the factory, the person is not allowed to go for the other kind of the employment. There is a restriction has been imposed, and so the person cannot go for this kind of the practices. And we are having the notice of the period of the work. So notice of period of the work is every day must be displayed in every establishment. So in section 31, see normally we can notice this kind of the notices, because then we see that like into the establishment sometimes the signature has been done by the workers. So they must have to display the work of every day. So after that, annual leave with the wages we are having. So the person would be eligible for annual leave with the wages is, so they must do work 180 days or more in a calendar year. And so if the someone is leave, how we'll talk about the leave rate is, 1 day leave can be granted for the every 20 days if the general work has been done, and 1 day leave for the 15 days. See if the someone is doing the work into the mines, or the underground mine worker is there, or adolescent worker is there. And if they are doing the work into the mines, then in that case either into the mines or the adolescent worker we are having, so then they would be entitled the 1 day leave after the 15 days. And so if the sometime what happened, the holiday comes, then they can be prefixed and the suffix, so they would be excluded from the leave. And we are having the special situations if the worker has been discharged, dismissed, or quits, or retires, or dies. In lieu of the earned leave, might be the person could not met with that criteria, but in that case their heir or the nominee, they would be entitled to get the benefit. So they would be taking the wages in lieu of the earned leave if the person for these kind of the grounds. So payment can be given in case of the discharge, dismissal, then or either someone quits the work, then within 2 working days the payment can be given. But if the person retire or the death has been caused, then in that case within 2 months this payment can be made. And we are having the provision here, the leave carry forward system here. So maximum 30 days leave can be carry forward, and leave encashment we are having the system. So like they can do that, and so the appropriate government is competent for this. They can make the other kind of the rules, and we are having the appointment of the inspector cum facilitator. So similar kind of the power has been given here, which has been given under the under the Factory Act. But here what we are doing, the similar power has been given, the similar protection. This person would be the public servant under the IPC, but only the name has been changed, inspector. So but here we are using the term inspector come facilitator, remaining things are same, but the few things has been added because inspection scheme. So here we have introduced the web-based generation, inspection plans, filing of the returns, and we are saying this is the duty of the employer is, that is they must have to maintain the register records and for filing the records, and so they can do it in that way. Employer can maintain it into the prescribed form, and electronically they can maintain, and because this thing has been provided by the appropriate government, so they can do in that way. So after that we are having just to get the benefit, unique identification number is there, has been given to all these persons. So and senior appointments can be made. We are having the chief inspector cum facilitator, and and the other authority which has been appointed here under this act, and this person is inspector or the other authorities, they would be considered to be the public officers. And so for the purpose of this code, power has been given to the inspector, so they are having the authority. They can access to any of the workplaces with the government or the public, or so they can inspect or they can examine any establishment or the premises, plant, articles, materials. They can inquire the accidents and the dangerous occurrence. They can take the statements, they can examine the plantations, crops, workers. So they can spread the information and the records, they can educate and desensitize the employer, workers, and they can require the production of the workplace and the work activity record. They can seize, search, or they can take the copy of the relevant register document for the offences under this code. They can direct, they can enter the premises item, and so during their inspection. So and for the investigation purpose, they can take the measures like photographs, videographs, recording. They can take the samples of the article substance or the air from the workplace or the vicinity. So testing of the dangerous articles, and they can detain if something they want to do it, and they can take enforceable action can be taken by the inspector, and they can give the show cause notice for the safety, health and the welfare. If there is a violation has been done, they can prosecute, and if they feel so, they can defend the cases if they feel so. So this kind of the exercise and the power which has been prescribed by the government, and they would be comply with the provisions, and so they are having the right, they can search and seize. This protection has been, power has been given through your section 94 of the CRPC. So they are having these kind of the authorities. So as we have discussed earlier, so employment of the women can be made into all the establishments after sunset, before and before sunrise. So into all these establishments, if they are agreeing to that, and after that adequate safety of the employment of the women in dangerous operation. So this is the duty of the employer, is they must have to provide the adequate safeguards prior to the employment of the women for such a operation. So this is the duty of the employer. Contract labor, this code would be applicable in which 50 or more contract labors are there, and so they would be getting the benefit under this code. Intermittent or the casual nature, so this won't be applicable upon the intermittent or the casual nature of the employment. This code won't be applicable. So for this contract labor, licensing is very important. So every contractor, they must have to, those who are making this supply or engage the contract labor in any of the establishment, or so they are providing contract labor without a license, they can be held, the penalty can be imposed and the action can be taken. So without a valid license, so they can't do that, and so license is required. and it has to be verified by the central government. So into like a number of the contract worker which the person can have allowed, and for this this contractor would be depositing the security. So sometime what happened, the work specific license can be granted to the employer, and so if this contractor is not able to meet with the criteria which has been mentioned, and this kind of the so specific work license can be granted, and this license can be renewed electronically within a prescribed limit. So that doesn't mean once the license has been granted, the person would be using it all the time. And so into which they will talk about hours of work, wage fixation, and the other kind of the things they would be doing. So again about responsibility for the payment of the wages, this is the duty of the employer. They must have to see bank transfer can be or the electronic mode can be given sometime. If the payment has not been made, the contractor feels, then in that case the principal can make the full payment, and later on they can deduct from the amount which they have paid it to the employer. And later on this amount can be deducted from the contractor security which they have deposited. After that, interstate migrant workers. So for the interstate migrant workers, the facilities has been provided. For this, the toll-free number helpline has been given, because this is the duty of the, again, the similar kind of the provisions. So they must to provide the safe working conditions, suitable residential accommodation, medical facilities, and the periodical medical examination. And employer, in case of the fatal accident and the serious injury, they must to inform the state governments of both the states. And in that case, they must to inform it to the next of the kin of the workers, into the family members. And the contractor had to pay the displacement allowances to the interstate migrant workers. The contractor has to pay journey allowances for coming and going. And again, an important thing is, so no suit or the other proceedings shall lie against the interstate migrant workers for the recovery of any debt after the completion of the period of the employment. If this migrant worker has taken any of the debt, the person cannot be prosecuted later on. And the benefit of the public distribution, for this, the person can avail this benefit either into the native state or into this state. So after that, we are having audio visual workers. For this, special provisions has been provided, but for this the agreement has to be set up and into the prescribed format, and it has to be registered to the, because otherwise no protection can be given. And as far as the mines are concerned, just to regulate the mines workers, then it is a duty of the sole manager to take care of these persons, and no person below the age of the 18 years shall be allowed to work into any mine or part thereof. And they must under the code, the power has been given to the central government to prescribe the vocational trainings and rescue and the recovery services of the persons employed into the mines, BD and the cigar workers. So for this here, under this code, no employer shall use or allow to use any of the premises into the industrial premises until the person is having the valid license for the purpose of this thing. So for this, the employer must have to maintain the register. Building and the other construction workers, again, the duty has been assigned it to the employer, and so this code prohibits the employment of any person whom the employer knows that he is having the reason to believe that this person is a deaf and having the defective vision or a tendency to giddiness. And for the plantation worker, it is a duty of the employer. They must have to make the provisions for the accommodation, drinking water, kitchen, toilet to every workers and their families. So crutch facility has to be provided. If they are having the 50 or more workers, education facilities has to be given. If they are having the age group is from 6 to 12 years and the number is 25, and they would be entitled for the health facilities, this worker himself and the families under the Employee State Insurance Act. And the recreation facilities and the welfare facilities has to be provided. So there is a this is the duty of the employer is they must have to make the for the plantation worker, if they are using any kind of the pesticides, insecticides, chemicals, toxic substances, then in that case they must have to take care, like otherwise we are having the system of the penalty can be imposed. Chapter 12, Social Security Fund has been set up for the unorganized workers, so it can be utilized for their welfare. And remaining section 128 to 143, it talks about the miscellaneous provisions in chapter 14. So very good provisions has been made, safety, health and the welfare of the workers, those who are doing the work into the respective establishments. So this is from my side. Thank you so much.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. I'm here to tell you a little bit about how we can think about globalization in a sociological manner. Now, one of the important concepts in the field of globalization and particularly global studies is that of global flows. It's a term that was developed by the sociologist and anthropologist Arjun Appadurai. He said that as the world is becoming a more and more global place, you increasingly see the movement of different types of things, both tangible and non-tangible, across multiple national borders. Um, to begin with, you can look at how your day proceeds. I often need a cup of tea to actually start my day. Now, if you think about it, tea that we drink is not something that is that originated in India. It's actually a drink that comes to us from quite far away in China. And this is something that has happened not immediately, but it has happened 400 or 500 years ago. So this kind of movement actually happened with the movement of people. Now, this kind of movement of people and goods is one category of flows that Appadurai talks about. A second category of flows could be financial flows. And a good way to think about this is the kind of volatility that you can see in economic markets today. For instance, in 2008, the whole world experienced a very serious economic jolt. Developments in the country of Iceland had a huge repercussion across many, many countries in the world. Now, that gives you an indication of the kind of financial flows that are a part of globalization. So, we are not only talking about money flowing from place to place, but also financial decisions made in one place having an impact on other parts of the world. Appadurai also argues that there is a third category of flows which he refers to as the flow of images or media. Now, this is something that I'm sure you're quite used to. Much of the programming that you watch on television today, for instance, you may actually be watching channels that have originated or programming that's originated elsewhere. More than that, it could also be that the programming that you see today is influenced by shows that have originated abroad. Similarly, you can have content that was made in India, which makes its way to other places in the world. For instance, we know that Bollywood films are extremely popular in many countries across Africa. So this kind of movement of media is, Appadurai considers it to be an important part of globalization. The fourth category that he talks about is the movement of ideas. So this means that ideas that are popular in one part of the world are not restricted to that part alone, but they actually travel across borders. So, for instance, something that you may read about in the papers would be, say, events such as gay pride events. Now, gay pride events have their origin in places like New York. But the idea that there should be equality between people, irrespective of what their sexual preference is, that is an idea that has now become popular across the world. And so that's the fourth category of flows that he referred to. The fifth category of flows that Appadurai talks about is that of technology. An easy way to think about this is, let's say tomorrow there is news announced that Apple is going to release iPhone 7. As you can anticipate, there is going to be a lot of excitement in many parts of the world, and people are going to start queuing up, waiting for those products to actually come to their country. So, technology is something that is quite exciting and really moves across various national borders.